Call the meeting to order, the Griggs County Commission, this January 28th, 2016 special meeting at 8 a.m. Pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Sorry, I forgot to put roll.
Okay, we'll take a roll. John Wakefield.
Here.
Dale.
Here.
Ron.
Here.
Troy's here. Sean, I'm sure he had to work. Do you want to make a note that John is attending by phone? Purpose of the meeting this morning is to discuss our current litigation situation. As we talked about in the last meeting, we would like to pursue mitigation. Jamie has recommended a fellow with Nillis Law Firm in Fargo to assist us. Ron and I met as a committee yesterday and talked to Mr. Giggler, the lawyer that has been selected by Jamie anyway for us to visit with. I think his opinion is that we should pursue with attempt a mitigation settlement with the building authority. I don't know how much time is involved with with mitigation as opposed to litigating this thing. If we still need to have somebody else do it, or if we can just do it ourselves, I don't know.
I don't know. I suppose the only reason they have is that Geisler.
Yeah.
I suppose the only reason to bring him on board would be so that if mediation fails, that he would be up to speed as far as going forward with the legal part, the trial part of it.
I can probably help out a little bit with that, John. Yeah, we have continuing deadlines with the court through mediation. We have mediation, but that doesn't mean our deadlines with the court aren't tolling right now. We had a deadline yesterday of getting our interrogatories out to each party. So we do have continuing deadlines. Mediation, it's going to cost some money to prepare for mediation and get dug up to speed, but if that doesn't work out, we still have to continue working on this case to prepare for a trial in December with discovery and getting our discovery out now and finding the potential expert witnesses and just preparing any motions that we need to make too in advance of the trial, because we do have deadlines coming up. And it's kind of a condensed calendar because Judge Tufte is not going to be a judge after the first year. He's running for the Supreme Court, so that's why this timeline would be probably a little bit longer, and the court probably would be a little bit more favorable to extending this thing off. But since he's going to be a judge only through the end of the year and likely be elected to the Supreme Court, he's pushing us along a little bit quicker than normal.
I think
My only disappointment, or I was a little discouraged that it didn't seem like these guys were really very interested in challenging the foundation of this whole arrangement between the building authority of the county and the Bank of North Dakota from the standpoint that they still like to think that this is a general obligation of the county, even if the underpinnings of the whole thing are invalid. And I can't quite get my head wrapped around that unless it's just bureaucrats protecting bureaucracies. I don't know.
I don't know if we can completely speak for Doug on that because he wasn't on board until Thursday and didn't get a whole lot of time to review the file. I think one of the, and I'm not really sure where Dan's coming from on that, but I think one of the things that Dan really emphasized yesterday, that would be a general obligation if the county was, if there was a judgment against the county for that amount of money. I'm not really.
But we're not a party to the bond, other than the lease contract. I'm not. I don't know if I agree with him on all that, all his. And I could be wrong. I mean, somebody show me some prior case law that somebody makes that stretch. I don't know. That just seems like it's not quite right, but.
I think, I mean, and not we're talking with these guys, but talking with other people associated with bureaucracy, and the same attitude prevails. And I would agree with them if this situation was the people of Griggs County had decided to go ahead with this form of financing and we're on board with building that courthouse. But the very fact that the people of Griggs County said no, we're not on board with that, and that we went ahead with the only means necessary to finance it, only means possible to finance it was this arrangement. The people of Griggs County not be held responsible for something that they specifically denied. And they specifically denied it. That's why we have this method of financing in place. So it can't cross that line. And the reason that it was able to be done this way is the reason that it can't be go back and be the responsibility for Griggs County. It can't be both ways. So people are reluctant, I think, to look at it that way, but that is the way it's looked at, and that's why it's in place this way. And we didn't make the rules; they made the rules. The prior county commissioners and the bondholders. Now they want to change the rules because the system in place isn't adequate to satisfy the requirements that were put in place before we started building this thing. So I believe that legally we stand, we have good footing. It's just getting someone to express that correctly. And I think the very fact that the lease agreement is written as it is, that it specifically lays out that the building authority is responsible for finance and building, and we're responsible for making the lease payments, is the basis of this thing. That's my opinion on it, and I don't know how we change it unless we're willing to just say, well, we're done with this then, and we go and put this before the vote of the people and see if they want to put more money into it to finish it. And I don't think that would be a viable alternative right now. If we're forced into that because of this court case, then that is our only alternative. But we have three different votes telling us what's required of the public officials, and at least from my standpoint, that's where I'm going to stand until proven otherwise.
Right. think if this went to a vote right now to finish this, it would pass, but that isn't really the question right of today. Today we need to decide if we want to retain this Doug Giggler to lead us through the mediation process.
I just have one other comment. I talked to Dan about what his hourly rate is for the insurance reserve fund. He's charging the insurance reserve fund $175 an hour. Doug Giggler is normally higher, but that was one of the things that he asked me if Dan was running a discounted rate working for the insurance reserve fund. Doug said he'd charge the same hourly rate as Dan is for the insurance reserve fund, so he's charging $175 an hour. I think Doug's either 200 or 250 normally, but because of Dan's involvement and the insurance reserve fund's involvement, he said he would charge $175 an hour for his hourly rate. And also that normally they would ask if for private citizens they would ask for a retainer. He decided that he would need to ask for a retainer from the county in this situation.
What will be their billing cycle? That probably get Doug's billing cycle.
I'm guessing monthly. That's in our conversation. I never specifically asked, but I would have to say monthly based on my experience.
They're going to try to get some mediation scheduled in February, if that's possible.
We gave our open dates yesterday. We're looking end of February, first part of March for mediation.
Right.
That's why we need to decide what we're going to do right now.
Well, I mean, you and Ron were in attendance, and Jamie, what's your recommendation?
I think, I guess I'm of the opinion, I think Doug's probably, out of the attorneys I've spoken with who would be willing to look at the case, I think he's probably has the most experience. And I think that, I know that he's worked in cooperation with Dan Gosta before on some cases like this, and I think they have a good working relationship too, and I think that's helpful as well.
Well, I think at the meeting yesterday, there was a communications breakdown probably from the very beginning, because I think we were formed as a committee to talk to several of these attorneys and then come back with a recommendation. And then the meeting started out, you already had the impression he'd been hired, or you had hired him maybe.
Well, I had already had the impression from the meeting that I was to hire him and have him come speak with you guys yesterday.
So at the meeting, I guess Doug had the impression he had a job, and then Dan Gaustad showed up at the meeting. So it wasn't really an interview. We didn't ask him what his experience was, and we didn't go over his role versus Dan Gaustad's role or anything. So it was a much different meeting than I thought, because I thought we were just going to more or less interview the guy and ask him questions. And that's really not what we did. Dan did most of the talking, and we really didn't get to learn hardly anything from Doug. He didn't say much. The few things he said didn't impress me very much. You know, he made that one comment about the performance bond. Why didn't you have a performance bond so he couldn't put a construction lien on it? Well, that doesn't make any sense.
Well, and he clarified that again after
He tried to, but
afterwards, because it's a private building instead of a public building.
but the performance bond wouldn't have anything to do with the construction lien on either a public or private building. So, you know, I wasn't very impressed with him, but that doesn't mean he's bad. It's just that we didn't really get to ask him about his experience as an attorney. And he's the only one we've talked to, but. So, maybe we go with him, but like I say, I'm lukewarm on him, but if he's the only choice we got.
I agree with Ron's observation of the meeting yesterday. It wasn't, not everybody came here with the same idea of the reason for the meeting. I think those guys came here to discuss how to proceed, and we came here to find out if this Doug Giegler was somebody that we felt would be competent to handle the case. I think his assumption was that he was already hired. With that said, at least for the mediation phase, I think we're, as the county and the county commissioners specifically, are going to have to set the parameters of the outcome that are acceptable anyway. So if he can get up to speed on this case, he's going to be working for the commission. So I still think our expectations of him are going to be defined by us. So,
well, and they always will be. I mean, we're the county is his client, and we have.
And I know, but we wanted to find out. This meeting yesterday was a competency interview, and we didn't get that done. You know.
That was my understanding of what that meeting was going to be. It was going to be an interview or basically to determine whether or not he was workable in our situation.
Right.
And I apologize, guys. I misunderstood I misunderstood the motion and misunderstood the action last week, and I'll take the blame for that.
With that said, you know, I think he'll be fine. Seems like he and Dan knew each other really well. Dan is up to speed on this, and we don't have time to monkey around for 2 months to find somebody.
And I'll be completely honest with you too, guys. There are a lot of people that don't want to touch us with a 10-foot pole.
So I guess my recommendation would be that we bring this guy on board, and I guess we're not going to know if he's competent until we work with him for a while anyway.
Yeah, well, we're just really talking about transfer of information. The people that know the most about this are the county commissioners that are involved with it. So to get up to speed, he's just going to have to be basically indoctrinated or sit down with us and we'll have to run the whole scenario with them, because that's the only way to do it. So if he's workable from that standpoint, then it really doesn't matter. And he's confident, and then it really doesn't matter who it is, as long as he's willing to do his homework and dig into this thing and work on behalf of the county. without any preconceived ideas about what the ultimate thing should be. That's my only concern.
Yeah, I don't think he knew enough yesterday to make that call. Dan Gosted has an opinion, but I don't necessarily agree with him either. But he doesn't work. He doesn't work for us either. You gotta. It's hard to keep that in mind too.
That's right. He has a allegiance to us, but most importantly to his main employer, which is the Insurance Reserve Fund. And that, as long as we keep that in mind, that he's going to do everything he can for us to the point where it's not a workable situation and it's costing the Insurance Reserve Fund money. It wouldn't have to be there.
Well, and I'll be honest. I don't think he's going to be involved through the entire case either. It's no secret. I mean, during the scheduling conference, he stated that he was going to be making a motion for summary judgment at some point when he gets all the discovery, and I think that on the counterclaim, I think that motion will be successful. So yeah, I don't think.
There's no use speculating because the speculation on things like that only interferes with concentrating on going forward with this thing to get the outcome that we expect. So I think just one step at a time, and the mediation is the first step, wouldn't you? I would think.
Yep.
Great. Yep.
How about the fees for mediation? How was that going to be split up?
50% to the building authority and 25% to the insurance reserve fund and 25% to the county. I spoke with Dan Gosted yesterday about that, and that's the way it'll work. But so the county will be responsible for 25% of those fees.
Yeah, they had some other ideas on that I really didn't agree with at all. Dan had said that he thought there should be just one commissioner representative attending it, and it should be in Fargo. And that, to me, that's like a divide and conquer strategy, to get one individual in Fargo surrounded by 2 or 3 lawyers and pressured into settling. So I'm against that, doing it that way.
That we're getting ahead of ourselves
All
here
right.
today. All we need to decide is if we're going to hire Doug to represent the county. But we don't want that type of discussion in.
Great.
Where will it take place then? It'll take place in Cooperstown?
To be determined.
Okay.
We don't know. But even on hiring Doug, there isn't much point, if Dan thinks the counterclaim is going to be dismissed, obviously we don't want Doug to spend a whole bunch of time duplicating what Dan's going to get dismissed.
Well, and that's not Doug's. Dan is working on the counterclaim. Doug's not going to work on that. The counterclaim is Dan's baby. It's insurance reserve's baby. That's.
Okay, but I guess
He was talking about us hiring forensic accountants. That's his problem.
That's his problem. That's Dan's.
And
situation.
but he's not going to get that dismissed unless he hires forensic accountants because there's still facts that are disputed. But I don't even want to talk about the counterclaim right now. Do you want to hire Doug or not to represent the county in the mediation? That's the question before us today.
Well, I'll get the ball started. I'll make a motion that we hire Doug for the mediation phase of this, and we'll move forward that way. Let's get the conversation started that way. So I'll make that motion.
Okay, it's been moved by John that we employ Doug Giegler from the Niles Law Firm to represent the county through the mediation process. Is there a second to that motion?
I'll second.
Seconded by Dale. Is there any discussion? Is there any discussion? Is there any further discussion? Seeing none, we'll proceed to vote. John?
Aye.
Dale?
Aye.
Ron?
Aye.
Troy votes aye. Motion carries. So at least we can get this ball rolling anyway, because mediation's gonna get here sooner than later, so.
Just gonna involve a bunch of meetings as we go forward, and we'll take it one step at a time and see where it goes.
Okay.
Move to adjourn.
Been moved by Ron to adjourn. Is there a second?
I'll second.
Seconded by Dale. Is there any discussion? Is there any discussion? Is there any further discussion? Seeing none, we'll proceed to vote. All in favor, say aye.
Aye. Aye.
Opposed, same sign. Motion carries. Meeting is adjourned at 8:26 p.m. a.m. You got p.m. on you, man.
Oh, I'm sorry.
Next regular meeting will be on February 5th at 1 p.m. and the following meeting on February 19th at 1 p.m.